Introduction: Understanding Authority and Legal Responsibility in Agency Relationships. In the previous sections, we examined how agency relationships are created through express agreements, implied actions, ratification, and estoppel. Once an agency relationship exists, the next critical question becomes what authority the agent actually has and who is legally responsible for the agent's actions. Agency authority determines what actions an agent is legally allowed to perform on behalf of their client, while liability determines who may be responsible when something goes wrong during a transaction. Real estate transactions involve multiple parties, including buyers, sellers, brokers, licensees, escrow companies, lenders, and inspectors. Because agents often act on behalf of their clients during negotiations and communications, it is important that agents understand the limits of their authority. Acting outside the scope of authority can create legal liability for both the agent and the brokerage. Arizona law recognizes several forms of authority that may exist within an agency relationship, including actual authority and apparent authority. In addition, the legal concepts of agency liability and vicarious liability determine when brokers may be responsible for the actions of their affiliated licensees. Understanding these principles helps agents protect themselves, their clients, and their brokerage while conducting real estate transactions throughout the Phoenix metropolitan area. Actual authority. Actual authority refers to the authority that a client intentionally gives to an agent to act on their behalf. This authority is created through the agency relationship and defines what the agent is permitted to do in connection with the transaction. Actual authority may be either express or implied. Express authority is clearly stated in a written or verbal agreement between the client and the agent. For example, a listing agreement signed by a homeowner in Chandler may authorize the brokerage to market the property, present offers, and negotiate with potential buyers. Implied authority refers to actions that are reasonably necessary to carry out the agent's responsibilities under the agency agreement. For example, if a buyer's agent in Gilbert is authorized to assist the buyer in purchasing a property, the agent may communicate with the listing agent, schedule inspections, and coordinate with escrow as part of the transaction process. These activities may not be specifically listed in the agreement, but are considered reasonably necessary to fulfill the agent's duties. Actual authority defines the boundaries of the agent's role. Agents should always ensure they are acting within the scope of the authority granted by their client. If an agent exceeds that authority, the agent may be responsible for any consequences that result from those actions. Apparent authority. Apparent authority occurs when a third party reasonably believes that an agent has the authority to act on behalf of a principal, even if the agent does not actually possess that authority. This belief is typically based on the actions or representations of the principal or the agent. In real estate transactions, apparent authority can arise when the behavior of an agent suggests they have authority to make decisions or commitments on behalf of their client. For example, imagine a listing agent in Phoenix repeatedly negotiating contract terms with a buyer's agent and indicating that the seller will accept certain conditions. If the buyer's agent reasonably believes the listing agent has authority to make those commitments, the seller may be bound by the agent's actions under the doctrine of apparent authority. This concept exists to protect third parties who rely on the reasonable appearance of authority when conducting business transactions. Because apparent authority can create legal obligations for the client, agents must be careful not to imply authority they do not possess. For example, agents should avoid statements that suggest they can approve contract terms without consulting their client unless the client has specifically authorized them to do so. Agency liability. Agency liability refers to the legal responsibility that may arise when an agent's actions cause harm to another party during a transaction. Because agents act on behalf of their clients, their actions can create legal consequences for both the agent and the principal. If an agent commits fraud, misrepresentation, or negligence while acting within the scope of their authority, the client may also be held responsible for those actions. For example, if a listing agent in Scottsdale knowingly misrepresents the condition of a property's roof to a buyer, both the agent and the seller could potentially face liability if the buyer later discovers the defect and suffers financial harm. Courts often examine whether the agent was acting within the scope of their authority and whether the principal benefited from the agent's actions. Arizona courts have consistently emphasized the importance of disclosure in real estate transactions, as demonstrated in cases such as Hill v. Jones, 1986. This case reinforced the duty of sellers and their agents to disclose known material defects that could affect the value or desirability of a property. Understanding agency liability helps agents recognize the potential consequences of misrepresentation, non-disclosure, and negligent communication. D. Vicarious liability and broker responsibility. In addition to the liability of individual agents, Arizona law also recognizes the concept of vicarious liability, which refers to the responsibility of one party for the actions of another. In real estate practice, this concept often applies to brokers who supervise affiliated licensees. Under the Arizona Administrative Code, brokers are required to establish supervision systems designed to ensure that licensees comply with state law and brokerage policies. This requirement is established under AAC R4-28-1103, which requires designated brokers to exercise reasonable supervision over the activities of their licensees. If an agent violates real estate laws while acting within the scope of their employment or affiliation with a brokerage, the broker may also face regulatory consequences. For example, if a salesperson in Mesa fails to provide required disclosures or misrepresents property information, the Arizona Department of Real Estate may investigate not only the salesperson's conduct, but also the broker's supervision system. The department may evaluate whether the broker had appropriate policies, training, and transaction review procedures in place. This is why many brokerages implement compliance systems that include transaction file reviews, documentation requirements, and continuing education programs for agents. These systems demonstrate that the broker is actively supervising licensees and promoting compliance with Arizona real estate laws. Discussion questions. Why is it important for real estate agents to clearly understand the limits of their authority when representing clients? Answer: because acting outside the scope of authority can create legal liability for both the agent and the client. How can apparent authority unintentionally create legal obligations in a real estate transaction? Answer: when an agent's actions lead another party to reasonably believe the agent has authority to make commitments on behalf of the client. Why does Arizona law require brokers to supervise licensees under AAC R4-28-1103? Answer: because brokers are responsible for ensuring that affiliated licensees comply with real estate laws and professional conduct standards.